Hi. I
How are
can't hear
you?
you.
Can you hear me now?
Oh, I know why. Hold on. Okay. Can I hear you now?
Yeah, can you hear me now?
Okay, there we go. I had this setting to change the setting. How are you?
Oh, good. How are you? Happy Friday.
Yeah, happy Friday. Um, okay, that looks good. I don't know. We'll see if bringing Carly on is easy or not.
I can definitely promote her to panelist. I can do it right now, or I can wait. She is
Yeah, if
on
you can see her, that might be easiest.
right now. So she should have gotten an invite. But yeah, we've got about a minute before we get started. So we'll give people just another couple minutes to join on. Thank you all for being here on this Easter weekend. Happy Good Friday to those of you who celebrate Good Friday, although I'm not sure if it's much of a celebration, but that's okay.
And Carly, if you want to rename, you can do that. Otherwise, if you're comfortable with your name, that's fine. Yep, you're in. Great, Carly. Thank you so much for being here.
How do you change the name?
I think you just hit the three dots in the upper left-hand corner of your name box,
I can do it for you too.
and then you can rename from there.
Tell me what you want it to be and I'll name it.
You can just do KW.
Heck yeah. Good to go.
That happens when I go onto another device. I don't know how to change the name.
Oh, I did it for you. I'm going to mute you though, okay?
Perfect.
Okay, wonderful. Well, then let's get started. I'm going to share my screen. Thank you all for being here for this Win Without Law School webinar on how to win sole custody. Let's get started. Does this sound familiar? If you are representing yourself and you have a family law case, you are probably feeling all of these things. You're probably feeling scared, overwhelmed, constantly thinking about what could go wrong or the worst case scenario. And you're not even sure, because there's so much information out there, what it is you're supposed to be doing.
Yeah, exactly. When you don't know what your options are and exactly how the legal system's going to work, it can be extremely scary. And when your kids are involved, you can really start going to that place where you're constantly thinking about the worst case scenario unfolding. And that can be problematic because then you're not necessarily coming into the case, putting forth your best arguments and your best case. Instead, you're just focused on things that might happen. And the problem is the courts really don't address a maybe. The courts want hard evidence about things that are happening, not fears of what may happen. So we'll talk about that today in more depth.
That comes up all the time, where people are truly scared of what is going to happen. And and just like Julie said, if we can't say it's happened before, it's very unlikely we're going to convince a judge that something might happen, and that is the worst thing. So welcome to Win Without Law School. You have come to the right place. We will be guiding you today and throughout everything that we do at Win Without Law School, so that you know exactly what you can do, exactly what you can't do. You will walk away today with skills and information that will make it easier for you to represent yourself. My name is Billie Tarascio. I'm an Arizona family law attorney. This is Julie LaBenz, Arizona family law attorney. And we need to give you some disclaimers, tell you about what we do, tell you about Win Without Law School. Julie, you want to do that?
Right. So Billie and I have both practiced in family law for many, many years. And what makes us a bit different is that we have a passion for trying to help people who are representing themselves and either don't have the funds or don't want to spend the funds on a family law attorney. So Billie and I joined forces in 2022 and created Win Without Law School. And what Win Without Law School is about is helping you not only understand what family law says, but also help you learn the skills to represent yourself really effectively in court. So we put together this program and we continue to try to educate people the best we can.
I see some questions coming in Q&A. If you want to communicate with us, absolutely type in your questions through the Q&A, and we will see about getting to those. Here's some things you need to know about Win Without Law School. Even though we're attorneys, we become your coaches, not your representatives. So our role is much, much different as a coach than it is as a representative. And because of that, you're not getting legal advice, and you're not getting attorney-client privilege or attorney-client relationships. You're not creating conflicts that would conflict out your opposing party. So it's really important that you understand, even though we're attorneys, we're not your attorneys. Even if you're members of Win Without Law School, we do not become your attorneys. We become your coach. We are teaching you the things that we have learned over our each 20 years. So combined 40 years of legal education so that you can shortcut that learning. You can represent yourself much better than you could have represented yourself if you didn't have all this information. The same way, if I was practicing law today, I know a lot more than I did 20 years ago. We are going to download this information to you. Our best case on strategy, on the mechanics of presenting your case, so that you can come out that much further ahead, because none of this is easy. And even though we are Arizona lawyers, what we're teaching are skills of lawyering, skills of communicating, concepts of legal analysis. So many of our members are far beyond Arizona. Did I miss anything on the disclaimers?
Yeah, just the basic ones are, this is legal information only. It isn't legal advice. We don't become your lawyers. And this is based around Arizona law because that's where we are licensed to practice. However, the laws are very similar in most states. So what we're going to do is show you what the laws are in Arizona, but then you can find the same or similar laws in your state.
Right. So if you hear something tricky about what we can do, and we'll tell you a statute, you probably have a counter statute, some sort of statute on the topic in your state that you now know to look up, which is very helpful if you're representing yourself. All right, so here's what we're going to share with you today. What you must know about sole custody, the difference between legal decision-making and parenting time, or legal custody and physical custody, how to develop a persuasive case with a theme and theory, how to develop strong evidence and what to do with it, how to identify if it's strong and what to do with that evidence and how to gather it, representing yourself at trial, amazing resources to help you shine in the courtroom, and answering your questions.
Okay, so let's start with part one, where we're going to get into these legal basics: sole custody, legal decision-making, and parenting time.
I'm just answering some questions, sorry.
Okay, yeah, go on to the
on
next
me.
one.
Go ahead.
Okay, so when you say sole custody, just saying sole custody doesn't tell the judge what you're asking for. It's too broad of a term. And in fact, in Arizona, I think it was back in 2012 or 2013, we changed sole custody into these two different concepts. One is legal decision-making and the other one is parenting time. So what this means is you shouldn't just say, I want sole custody. You want to make a request regarding legal decision-making and then a request for parenting time. So let's first focus on legal decision-making. What is it? Because this could be interpreted very broadly, but if you look at the definition in Arizona law, it talks about legal decisions related to education, medical, religious training, and personal care decisions. And often decisions around extracurriculars can come up in this context as well. So what you're looking at is, do my co-parent and I, are we in dispute regarding our kids' school, regarding their healthcare, regarding their religious training, and regarding their personal care decisions? Because if you can come into court and verbalize what it is about school and why you need sole legal decision-making on that, or medical, that's going to be a more persuasive case than just saying, I need to make all the decisions.
Right. Or I've always done it this way in the past. That is not a good reason to be given sole legal decision making, at least in the state of Arizona. And the reason I put a question mark after extracurriculars is because extracurriculars is not defined in the statute as part of legal decision making, but it's one of those things that happens at both houses. Usually it requires cooperation of both houses. It's almost impossible, especially for teenagers or even preteens, to engage in extracurriculars if one person says yes and one person says no. So I have seen that go to court many times. And I think it would be helpful if maybe extracurriculars was covered under this legal decision-making umbrella. Also, personal care, what is it? I don't know.
It is. It's a really broad term. And honestly, that usually isn't where the biggest fight is. It's
Right.
generally around education and healthcare.
Absolutely.
Is usually where that's the most common concept that people will fight over in court. Personal care decisions are like haircuts and what they wear and things like that. And usually parents just figure that out. I mean, you really don't want to judge jumping into that type of stuff, at least from my point of view. And so usually the parties work that out. And religion is only a disputed issue in certain cases. Either the parents have the same religion or don't practice a religion. The religious part only comes up if there's a major difference between the two religions, and if it isn't possible to exercise both in each parent's individual households.
Yes.
So really we're looking at school and healthcare. And when it comes to schooling, you know, for some people, their kids go to certain schools and they're going to keep going to those schools. And the parents agree, and it isn't a big issue. But for other families, it's a huge issue about which school the kids go to.
Yeah, whether or not they're homeschooled, whether or not they go to private school. I mean, they can be huge issues and you can't compromise on that. But I want to ask your opinion, Julie. Yesterday, a question came up in the Modern Divorce Support Group where mom doesn't want the 14-year-old to start shaving. And 14-year-old asked stepmom to buy her razors. And I gave a perspective, but I would be interested to know your perspective. Do you think that that falls under legal decision-making or a general parenting decision that each person gets to make?
It's certainly up for debate. I mean, I think that could fall under the personal care decisions, especially if it's about shaving for the first time. You know, I think it could fall under there, but I don't think this is something a judge is going to want to hear about. You know, I think this is something that there should be some communication about between the parents ahead of time, and ideally some sort of agreement reached. What do you think, Billie?
Yeah, I mean, my perspective was that it is a parenting decision that can be made on each person's parenting time. So to me, it's one of those things that you can shave at one house and not shave in another house. That's unlike piercings, which are permanent and they travel back and forth. So my advice to stepmom was, you know, if dad's okay with it, it's really dad's choice. And if dad says it's fine for you to buy his daughter razors, then go for it. So, but people disagreed and people were like, wait, isn't that legal decision making? Shouldn't mom and dad talk about it? And so there is some gray. And that's why I bring up that example, because it's gray, but is it going to go to a judge? No. Are you going to drop 10 grand on a lawyer? No. Are you going to file a petition and spend $350 and then go to court about a shaving that's already happened? No, you're not. So practically speaking, you lose some control when you're divorced, regardless of whether or not you're awarded legal decision making.
A lot of people don't realize that there's 5 different ways that you can request legal decision making. A lot of people just think sole or joint and that's it. But really, there's options within those different categories. So of course, there is just straight up sole legal decision making to one parent. Or you could break out, you know, the education, the healthcare. You could break those out and say, look, we have joint for everything, but I have sole on education, or I have sole on healthcare. You can just share joint decision making, or you could have joint legal decision making, but one parent has final say if the parents aren't able to reach an agreement. And then you could limit it to final say only on certain issues. So there's a lot of different options here. And I really recommend that people get detailed with their request, because when you can come into court and verbalize a really specific request about why you need final say or sole in one particular area, I think that can make a really persuasive presentation.
I agree. Judges in Arizona do not want to give one parent the upper hand if they can avoid it. So they're going to give you the most limited amount of power or authority over the other co-parent as you need in order to get things done. That might mean a judge orders that you have final say on medical only for one of your children only, the only one that there's a disagreement about. So it's something to keep in mind. And if you are going to court to make this case, think about how specific you have to get. You have to tell a judge a great reason for why you need the ability to make a decision over the other parent's protest, because they're limited to only really medical and educational in most cases. And religion comes up so little. Now,
All right.
go ahead.
Now we're going to talk about parenting time. And as Billie referenced earlier in the example about whether or not the daughter could shave, a lot of decisions are made during each respective parent's parenting time. So, when you're looking at parenting time, you're really looking at what is the reason for your requested parenting plan? Is it because your co-parent is a danger to the children? And if that's the case, you're not likely going to be able to say 0 parenting time to the other parent. I mean, you can make that request, but the judges are often looking to give some amount of parenting time. So even if you have strong evidence about endangerment, you may need to create a proposal around supervised visits or just daytime in a public place, some sort of proposal that protects your children, but also allows the other parent some amount of parenting time, which can sometimes be a difficult path to walk.
Absolutely. And in many states, this is referred to as legal custody and physical custody. Mm-hmm. Arizona got rid of the word custody, which Julie was just touching on earlier. And we don't even use the term custody as a legal term in Arizona anymore. It's only parenting time and legal decision making, but most states do the same thing with different names. You want to request sole legal decision making if you have a decision and a judgment conflict that is preventing you from getting your kids counseling or medication or private school or homeschool. You want to request the majority of the parenting time or most of the parenting time. As Julie said, if there's a safety issue or if there's a practical reason that makes it so that you can't share equal.
Okay, so now let's talk about, or just one final part on the parenting time before we move forward is, just like with the legal decision-making where you want to make a specific request, it's the same thing with parenting time. You'll need to make a year-long parenting proposal that's really specific. What are the dates and times and locations for the exchanges? What happens during holidays? What happens during summer break? What happens during school? What happens on 3-day weekends? How about vacations? How do those work? So just keep in mind, you don't want to go in and just say, oh, I want a fair parenting plan.
Right.
That isn't detailed enough. You want to draft an actual year-long parenting schedule proposal. All right. So with that said, let's jump into part 2. Let's talk about how to build your case. So once you figure out what you're requesting, then what?
Oops, did I go backwards? Yeah, I did. Go ahead.
Yeah, so one beginning point is to start developing your case theme and theory. Custody issues are largely factual, so you'll need to get crystal clear on your arguments. So one, example that comes to mind of a theme and theory is from the O.J. Simpson case, where they said, oh, if the glove doesn't fit, you must acquit. Mm-hmm. So, the theory is that, well, if the glove doesn't fit, then he didn't do it. And so then is your case theme, you must acquit as a result. Now, you don't have to come up with some catchy thing at all. Oh, your screen just changed.
Uh-oh. Let me see if
Yeah,
I
go
can-
back to screen share on the slides. So it's not that you need to come up with some sort of catchy phrase or anything like that, but it's more about coming up with a very clear request, and it should be consistent. So you're looking to show not only what you want, but why. And that is really your case theme or theory, or theme and theory.
Yeah, you want it to be catchy, easy to remember, kind of quippy almost. Like, well, I mean, if it doesn't fit, you must acquit is a great example. Other family law examples are things like, this is the child's home, if you're dealing with a relocation, or whatever. It's how do I make the case as simple as possible and sum it up into a sentence or two? Okay, you can see my screen, right?
Nope.
Oh, not anymore. Okay,
No, we're just on the screen with our pictures.
there we go. Good
There
to
it
go
is.
now? Okay,
Okay,
sorry
yeah, so
about
let's
that.
move on to the next slide.
Ooh, this is a big one.
Yeah, go ahead.
I mean, judicial discretion for custody cases could not be broader. The abuse of discretion standard, which is a appellate standard, means that judges get to decide whatever they think is best as long as they follow the law, which means really making findings or explaining their thought process. If judges properly explain their thought process, it's almost impossible to get a case overturned on appeal, which means you have to make your case to the judge in front of you. You're probably not going to get a do-over. And it really is about convincing the judge of your perspective.
All right, so as you're jumping into this of getting, this phase of getting your case prepared, you certainly want to read and understand the custody laws in your state. And then you want to also remember this formula that we use in our legal pleadings, which is to, number one, identify the issue. So here it could be, what is in the best interest of the children regarding legal decision making, or what's in the best interest of the children for parenting time. And then the rule would be what the law says about decision making and parenting time. And then your analysis would be analyzing, okay, given the law around decision making and parenting time, this is what's in the best interest of our children, and this is why. So this is when you're analyzing, the medical decision making, the educational decision making, the year-long parenting plan. This is where you're arguing over why your proposal is best for your kids. And it's ideally, you're putting that in the context of your state's best interest of the child standards. And then that brings you to the conclusion where you're asking the court to order your requested decision-making and parenting time plan.
This might sound a little boring or a little bit like, why do I need to do this? But our entire first year of law school is spent largely learning the law and learning this. A whole year for lawyers, and every single lawyer goes through this. So if you want more on this particular topic, we covered it a lot in our last webinar, and we get into it a lot in Win Without Law School. It may sound boring. It's not. It's incredibly important.
Here's a list of some statutes in Arizona to take a look at. And some of this I've shared in the daily emails, so you can find some of these statutes in there. And this is good too, because this is what you'll want to be looking for in your state. So first we've got the definitions, and then there's the best interest of the child standards. 40301, that has some information about what to argue if you have a dispute about legal decision-making. It has some of the factors the court needs to consider. And then if your case involves domestic violence or substance abuse, there's specific statutes on that as well, and how it plays a part in decision-making and parenting time.
We also Originally in this presentation also discussed relocation, but we don't have time to get into relocation. But if you're arguing about which state somebody should live in, somebody has to have sole custody, there's different factors for that. So it's really important that you look at all of these statutes before you even get started. So with regards to your theme and theory, then you apply it to your statutes.
Here is a list of Arizona's best interests of the child standards. And this is where, when you're arguing for legal decision-making and parenting time, you can argue it within this context. And one of the best ways to do it is to go point by point.
Mhm.
All right, Judge, now I want to tell you about the past, present, and potential future relationship between each parent and the child. And then you can talk about that and tie it in to your requested outcome. Now, not every single one of these standards is going to apply in your case. So you'll want to pick out the ones that do and then start crafting your evidence and arguments within these different standards. It can be a little bit awkward. It can sound a bit strange to talk about some of these things, but this is what the judges are required to make findings about. So it's really important to talk in a way that the judge can make an order in your favor. You want to make it as easy as possible for the judge. So if you can argue in a way that the judge understands, and a way that the judge can, put out their order and make a ruling in your favor, that's really favorable.
The other thing is, if you've got something that has happened that you really want to talk about, but you're not sure how to talk about it, look at the factors. If, you hate the stepmom, let's say you hate stepmom, and you really want to talk about how awful stepmom is. Well, other important relationships is the place where you would talk about the stepmom. You would say, while the child might have this relationship with their parent, the other relationships at, the other house is, completely dysfunctional. And that is where it would be relevant. Where you might think, I can't talk about the other relationships in that house that are as dysfunctional because they're not part of the case. You can, if you do it correctly under the proper factor. But if you don't do it correctly, they're going to shut you down.
Yeah, that's a really great point. So I mentioned earlier that there's specific statutes that talk about domestic violence or substance abuse. So this, when we're looking at if there's been domestic violence and child abuse, here are some of the presumptions that come into play with that. So if you can prove domestic violence and or child abuse, joint custody should not be awarded. So that would mean no joint legal decision-making, no equal parenting time. And this is in cases of significant domestic violence. So of course that raises the question, what is significant?
There is some case law on what factors constitute whether something is significant or not. The timing matters. I don't remember all of the factors off the top of my head, but there are things that you would think should matter. The severity of the incident, the timing of the incident, the consequences of the incident, that sort of thing. Legal presumptions matter a lot in these custody cases, because if there's a legal presumption that goes into place, then the standard changes. So the standard, if you and your ex go in front of a judge and there's no domestic violence and you both live in the same place in Arizona, you're probably looking at an equal parenting time schedule. You've got two good parents. Even if, dad or mom says, I'm the person who's made all the decisions, I want legal decision making, I'm the better parent, a judge will not care, will not want to talk about it. If you prove domestic violence or substance abuse per the statute, the presumption changes. Now the judge has to give the non-offending parent legal decision-making unless the other parent has all these reasons to overcome that presumption. So it really does change the analysis. It's incredibly important if there is DV or substance abuse in your case that you do the work to understand these legal presumptions before you go into court.
And Billie, one more point on that. Let's say you're the one being accused of domestic violence and you dispute those allegations. You probably want to take a two-pronged approach here. Number one is seeking to prove that you didn't commit the domestic violence. But then the second part is showing how we're looking at number 4, showing that you've been rehabilitated.
Yes.
In other words, well, I deny that happened, but even if it's proven that it did, these are the steps I've taken to be rehabilitated. I did an anger management class, or I've been in counseling. I'm doing family counseling. I'm on different medications or something. Sometimes you have good evidence to disprove the domestic violence allegations, and sometimes you don't. And if you don't, then you're looking at how can I rebut and how can I overcome these presumptions based on the things I've done to show that I will not commit domestic violence going forward.
And once again, the statute becomes really important. The statute tells the judges some of the ways the presumption can be overcome. So when we're working with clients who have been accused of domestic violence or who have had a history of domestic violence, we're looking at that statute and saying, look at all these things that you need to do before we get in front of a judge, so that you can say either it didn't happen or yes, we had a horrible toxic relationship and it resulted in some awful things, and I take accountability for these things, and here's all the things I've done to make sure it never happens again, and I'm not a danger to my children. If you can do that, you can overcome that presumption.
And then also, be aware that if you prove domestic violence and the presumptions go into place, it doesn't necessarily mean that the offending parent gets no parenting time.
Right. We're just talking legal decision making. And the statute also talks about what protective measures need to be in place to protect both the victim and the child, if the victim is the other parent, from violence while still allowing parenting time.
So that can be really important in making your parenting time request, is looking at that and saying, okay, what specifically will prevent any further abuse? Not just a blanket, no contact, but looking at, okay, we could exchange outside the police department, or it's only a daytime visit, or it's supervised, really coming up with a very clear proposal, whether it's domestic violence or substance abuse, that's going to protect against the harm. That's what the judge is going to want to hear, not just no contact, no parenting time, but what sort of schedule would protect everybody involved while there's still some contact. And, not everybody agrees with that. Some people want the courts to just cut off contact, but in my experience, that's not how things unfold. So that's why we're talking about it in these terms.
Right. And getting practical protections in place is really useful. Like if you are always worrying over, transportation or whatever, then we should start thinking about how to remove that barrier, practical solutions that can get put into your parenting plan that will prevent the conflict from moving forward. We could do an hour on DV, and we're only at 17 of 44, so we gotta move a little faster, but there's so much good information here, we may have to do a part 2.
So substance abuse is somewhat similar to the domestic violence inquiry. And here, what the court is really focused on is what's happened in the past year. From the date the petition was filed, what happened in the past year regarding substance abuse. The court's not wanting to go back 5 years, 3 years, 10 years. They're wanting to look at in the last year, what's going on. And so that's where, if you're going to file something, you need to have evidence within the last year, at least in Arizona. That's part of the initial burden to file or to make a request under the statute. But as in the DV statute, there's an opportunity to rebut the presumptions. And that would be through providing proof of sobriety.
Right.
Now,
And so let's say you have convictions or mental health stays or whatever. Let's actually stick with addiction. You have this long history of rehab and relapse and blah blah blah, and but you don't have a conviction within the last year's window. This presumption under this statute may not apply, but if you go back to the 13 best interest factors, it can still come up. You can still talk about it. It just might not trigger that legal presumption.
Okay, so now you have your case strategy. You've gone through the legal analysis. Now let's talk about gathering and presenting effective evidence. So, Billie, what are your thoughts about what type of evidence is effective in terms of decision-making?
Okay, so in terms of decision making, we're dealing with a conflict over what is best for the children with regards to medical or educational. So you're going to want records. You're going to want diagnoses. You're going to want recommendations from doctors. You're going to want school records, in addition to your testimony. But they're really, if we're talking about legal decision making, there's two philosophies, competing philosophies from parents on what's best for children. And you need to prove why your proposal is better, and also why it is that you can't come to the same agreement on that. You know, why can't you come to an agreement on the best school or whether or not to medicate? And then a judge is going to make a decision based on that.
So really what you're looking at are, what are your reasons why? Why do you need the custody or the legal decision-making you're requesting? Why do you want the judge to order your parenting plan? And when you start to think about those whys, that's where you're going, okay, what evidence can I gather that proves the why, that shows, the substance abuse, the domestic violence, the school choice, the medication issue, or even just a parenting schedule that's better, for your children. So
And specifically, just to build on that, specifically, what is the impact to your child of the decisions? Not why are you right and they're wrong, but what is the impact to the child from this decision versus this decision? You have to demonstrate why what you're asking is in the best interest of your kiddo.
So in addition to school records, medical records, things like that, you can also create what's called demonstrative exhibits. So if, for example, you have a situation where maybe you had a temporary parenting order and the other side didn't follow it, you could you can create a calendar and highlight all of the days that they missed. And that can be a really great visual. I also recommend make your proposed parenting plan an exhibit. Type it all out, have all of the details there. That is a great exhibit. Now, don't forget to disclose. Anything that you want to present at trial, you must disclose to the other side. And then in addition to what you disclose, let's say you want to get some information from the other side. You get that through discovery. Now, we cover disclosure and discovery a bunch in Win Without Law School, so you can get more in depth if you join. It's not the focus of today, but I definitely want to bring those things up. And then, of course, if you're representing yourself at trial, you got to manage your trial time. You got to know how to present your exhibits at trial, and you got to know the rules of evidence, which are things that we teach in our program.
This is a big deal. You cannot go into court and represent yourself without taking our trial skills course, unless you have gone to law school, unless you're taking somebody else's trial skills course. There are rules that allow you to get evidence in or not. And I told a story last time about some people who had filed their exhibits and they thought it was all admitted and it wasn't. So it's really important that you know the rules. Oh, sorry. What was your pro tip?
Well, I think what you just talked about is our pro tip, which is just filing your exhibits with the court is not enough. If you just file them, they're just filed. They're just there for you to utilize at trial, but you actually have to get it admitted into evidence. And the judge is not going to review every single exhibit that's been filed with the court. The judge is only going to look at those exhibits that have been talked about during the trial and admitted into evidence. So the understanding trial procedure and how to work with your exhibits and get them admitted into evidence, it's just, you have to know how to do that. Otherwise, it's nearly impossible to prevail.
Absolutely critical. Just critical.
All right, let's talk about this more. Representing yourself in trial.
If you are representing yourself in trial, there's some things you can do to prepare. First, I already said you have to take our trial skills course. It's really important to understand how evidence works, how the flow of trial works. And one of the things that Julie helps people do is create trial outlines.
So a trial outline is your script. It's what you go into court and you have it all written out what you're going to say. Now, of course, you need to be flexible. You need to listen and go with the flow. You may make some edits to it during the trial and some additions, completely fine. But it's so helpful when the judge turns to you and says, Ms. Tarascio, your witness, that you know exactly what you're going to say. You know the questions you're going to ask. You know the exhibits you're going to present at the exact moment. You know how to get them admitted into evidence. And within Win Without Law School, we have trial outline templates for divorce cases, for custody cases, for modifications. So it's really helpful because you can utilize that and just plug in all of your stuff into the outline. You don't have to start from scratch.
That template is so valuable. It is worth the cost of Win Without Law School on its own. There are lawyers who have been doing this for many more years than I have, who still rely on trial binders for every trial, or certainly for complex trials. You cannot afford not to have this if you are representing yourself and going to trial.
So when you're at trial, if you're representing yourself, you're responsible for conducting direct examination and cross-examination. So direct examination is when you call a witness up and you ask them questions. Cross-examination is when the other side has a witness take the stand and you ask them questions on cross. There's a lot of techniques, there's a lot of strategy around this, but the most important part is that you need to draft these questions ahead of time. Because if you are in trial and you don't have this stuff prepared, and the judge turns to you and says, okay, Ms. Tarascio, time to cross-examine the opposing party, what are you going to say?
Make sure you lied about blah, 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 blah. Nuh-uh. Like, you can't do that. There are rules about how you ask the questions, what's leading, what's admissible, lots of stuff.
And this is your chance. This is your time to shine and tell your story and ask your questions. So are you going to really shine in this moment? Or are you going to start crying because you have no idea what to say and it is so stressful and scary? And I'm not kidding. It is unbelievably overwhelming to have the judge turn to you and say, it's your turn to talk, and you have no idea what to say.
Right. It's not unusual for people to be shaking, for the adrenaline to be absolutely just coercing through your body.
So let's start to bring this all together. What does it take to win sole custody? You've got to understand the law. You've got to understand the rules of procedure. You need to understand how to apply the rules of evidence, create your case theme and theory, create your trial outline, and then have and apply trial skills. This is kind of the start to finish of, initiating your case to the final point, everything in between that you'll need to do to get to this point.
Yeah, I mean, we told you this webinar would teach you how to win sole custody in your family court case. And the truth is that this is what it takes. It's a lot. There's no quick fix. There's no simple, easy answer that we can give you. It takes a lot to win sole custody. And it's important. There's nothing more important than your child's safety or what's in your child's best interest. But you're not going to get it without putting in significant time and work to understand the system and prepare for your case.
So how are you guys feeling right now? I mean, are you feeling like you need help? Because you don't have to go through this alone. You don't have to continue to struggle trying to figure this all out based on internet searches that, are just giving you random pieces of information, but really not bringing it all together for you in an easy to understand way.
Or advice from Facebook groups, or what your mom's telling you to do. Like, there truly is an objective way to learn this.
You need answers to your questions. This involves your kids. This is going to impact not only their lives, but your life. You need a real solution to the co-parenting problems that you're facing. And we'd like to help you. Of course, you can go and hire a lawyer, and that could be the best option if you can afford it. But there's so many people out there who can't, or they already had a lawyer that they spent all their money on, and they don't have any money left for a lawyer. And that's where Win Without Law School comes in. What would it feel like to have 24/7 access to legal resources, get answers to your questions, have confidence, and have a community? That's what we provide.
I can tell you that I have been trying to, since 2010, I have tried probably 4 or 5 different ways to help provide resources to people self-representing. Because very early on, getting out of law school, it was 2005 when I got out. And so we were just getting into this huge recession, and there were all these people who couldn't afford help. So very, very early on, within months, I was like, oh, these are the people I want to help. Even though I went to law school, even though I passed the bar, I want to help people who are representing themselves, people who can't afford lawyers. And it's a very, very difficult thing to do. But this system, the combination of getting support from a lawyer, a community, and actual courses and templates is the key. It's finally the thing that can truly help people represent themselves.
So what's included? First of all, we have courses that cover pretty much the gamut of family law. And then we also have some planners you can utilize. We have the trial skills course, the trial organizer, and then we have the Facebook group and Q&A sessions as well.
And the live Q&A sessions are really where I think the most valuable part of the program, because information is readily available, and the way that we've packaged it is so good. It's so step by step, piece by piece, clear and easy to understand, but still you're going to have questions about how to apply it to your case. And that's where the Q&A just becomes so, so valuable.
So is Win Without Law School just for people in Arizona? No, it's not. Of course, it's focused around Arizona law, but we have members from all over the United States that have found value in the program. My ex.
Oh, sorry, go ahead.
My ex is a narcissist. Can you help me communicate with him or her?
Yes, we can. I mean, we're not going to communicate with your ex for you, but one of the things that you pick up along the way of the many years of litigating is tips and tricks for how to diffuse situations, or what to respond to and what not to respond to. And so much of what people are dealing with when they're going through a divorce or custody case is, what do I say? What should I say? I know everything I'm saying is going to turn into an exhibit, and it is. And so what you say and how you say it matters. And that is something we spend a lot of time talking about.
Will you answer my specific questions? If you're in the level 1, you can post your questions in the Facebook group. And if you're in the level 2 or 3, then you get access to the live Q&A sessions Monday through Thursday from noon to 1 Arizona time. Yes, we can help people prepare for specific hearings. In fact, we do that quite often. Ideally, you want to join, when there's sufficient time to prepare. You don't want to join a few days or a week before your hearing.
Right.
Ideally you're joining, maybe 30 days before, 60 days
at
before.
least, because your disclosure deadlines are going to be 30 days before. And then if you want to do discovery, you need a good 40 days before that. So my recommendation is you want to join at least 3 months before your hearing, before you have any scheduled hearings, so that you can get all of this information, build the trial binder, do the discovery. So if you have that ability, 3 months, my advice, but anything is better than nothing.
Will you do we review documents? We do. Either you can post your proposed documents in the Facebook group, or you can bring them to the live Q&A and we'll talk about them. I mean, including your trial outline. We can go over your proposed cross-examination questions, for example.
That is so valuable, because after years and years of doing this, you learn what questions are effective and what questions are not. And so it's just really helpful to have people bring their actual documents or their actual questions and get feedback and get a better result because of it. So I hope that you all have gotten value out of this webinar. And if you're not already members, that you would consider joining, because it's a game changer. You can now effectively represent yourself with support, with coaching. It's the only way you can get a lawyer alongside you. Maybe we're not in front of you, maybe we're not speaking for you, but we're alongside you, coaching you and supporting you every step of the way.
Okay, but you don't have to just take it from us. We actually have a member here of Win Without Law School who's going to share her experience.
All right.
Let's see, let's have you unmute. KW, when you're ready, just unmute. There you go. All right.
I just wanted to address some different aspects that Billie and Julie had mentioned in the presentation. You can join with and without law school if you are not represented and just want to do everything on your own. They definitely will give you the resources and information to empower your case. But also, if you have an attorney, it is still so helpful to be a part of Win Without Law School. I have an attorney, but I have joined Win Without Law School, and it has made my conversations with my attorney much more efficient. It is much cheaper to have your answers ahead of time and not just going back and forth with your attorney. One email to your attorney could cost you almost $500, and an hour, 4 days a week, so 4 hours a week of getting your specific questions answered is so helpful. And yes, you can just do the lower levels and just post your information on Facebook for the group, but you miss out on getting that direct communication or it's not always one-on-one. It depends on how many people join the live Q&A, but just getting that time to get your specific questions answered. And they will, like they said, do a document for you. They can help write out how to do a community spreadsheet, a settlement offer, wherever you're at in your case, in order to make it work for you and the best for you in your case.
Can I ask, how much money do you think you've saved in legal fees by joining Win Without Law School?
I am on the Q&A almost every day. So I would say that would be about $2,000 a week that I save. So $8,000 a month.
Ooh, girl. Well, thank you so much for your time and for your testimony and your willingness to be part of what we're creating. Thank you so much. Anything else, Julie, for her?
No, thank you so much. We love having you as a member.
And we hope that the rest of you are willing to join. Here is how the pricing works. Here's how the program works. You can join our essentials package for $599 for a year. That gets you all of the courses, all of the templates, the trial binders that we were talking about, access to a private Facebook group. This is not the Modern Law Facebook group that has 18,000 people. This is only members of Win Without Law School. There's a confidentiality agreement within those members, and access to recorded Q&A, but you yourself cannot join the Q&A. And the Q&A is what KW was just talking about, where she shows up 4 days a week to ask questions, bring her documents, and get personal feedback. That personal feedback comes in this interactive level. And at the interactive level, it's $14.99 for a year, or you can pay monthly. Let's say that you know you've got a trial in 3 months and you don't want the full year. You can pay monthly on any of our levels. On the highest level, you are getting everything in levels 1 and levels 2, plus 4 individual coaching sessions when you sign up for this annual membership of $24.99 per year. And for those of you who are here today, we do have a coupon. We're going to make you an even better deal, even though this is like the value is really, really there. But for those of you who are here, here's another beautiful testimonial. We're going to give you 30% off on levels 1 or levels 2. And what you need to do is go to winwithoutlawschool.com, pick your membership, and use the coupon code WWLS30.
All right. I think we're now at Q&A time.
Excellent. There's a lot of questions that I have here, and we will try to get to as many as we can. I can stay on for a few extra minutes and see what I can do to answer these questions. Let me just peruse through here, because the first thing I'd like to do is answer any questions that people have about membership, because many of these substantive questions would probably be better when you're in the membership, when you're at Win Without Law School and you've got time with an attorney one-on-one. So let me see if there's any.
All right, while you're doing that, I'm going to go through some of these other questions. The other parent did not follow the emergency order over spring break and brought a person of concern around the kids, which was the reason for the emergency orders in the first place. when is it appropriate to withhold? Is it okay to make the other party file enforcement instead of us constantly filing emergency orders? Again, my question is, when is it appropriate to withhold? It's always risky to withhold. If you're going to withhold, then you need to have cause. And there also should be some sort of solution. I mean, are you going to withhold forever? So I think that you're going to have to be very strategic in deciding if and when to withhold and for how long. But you'll want to tie it to some sort of endangerment to the children.
I hope all of you take the time to read some of the open questions, because many are from members just giving feedback. But here's one question, Julie, what study tools did you use to learn the rules and the procedure?
I didn't use any study tools. I just read through it all. I mean, I can't think of a tool. It was really just familiarizing myself with it, and then obviously seeing it in action through being a lawyer and being in the court system.
Yes, I would say the way that, Julie and I learned to practice is not the crash course, very efficient way of Win Without Law School, but the long, many, many, many hours of reading. Next question, if you can afford an attorney, but you can't get an attorney to help you, and you still can't afford to sign into your school. Okay, I don't understand that. I'm sorry.
How can a person get permanent full custody and supervised visits? How can I prove this when the abuse was so covert and done behind closed doors? So we talked about that a lot today. You testify to it. Your testimony is evidence. So you would testify as to what happened. I don't think there's ever an option to get permanent custody. It could be modified in the future, but you could get an order for that now. Is it possible to go ahead?
Does your platform teach how to create and properly file or serve subpoenas?
Yes, that's in our disclosure and discovery section. There's a video about it, some forms, and then of course, people ask questions in the Q&A or the Facebook group about subpoenas, and we'll answer those.
Can someone actively changing positions on legal decisions like education and medical provide grounds for a request for sole legal decision making?
If the change in decisions is negatively impacting your children, then yes, I think that could be at least one part of the grounds to change things.
Yeah, I mean, I think people changing their minds is allowed if they're evolving, but let's say you are unable to lock anything down because your co-parent is so all over the place and they'll never commit to anything. That would be a good reason that you might need legal decision making.
Is it possible to gain sole legal decision making plus majority parenting time after I gave my ex majority parenting time and combined legal decision making? I think that means joint. I previously had sole for both, gave him a chance to take a larger role in the kids' lives a year ago. It is now resulting in parental alienation. You may be able to move back to the middle to some sort of 50-50. I think if you're going to go all the way to the other side, and get sole plus the majority of parenting time, you'd have to have some really strong evidence about why that's best for your children.
I mean, that's a great example of when you make a choice like, hey, we're going to try something. I would not recommend you make that permanent until you try it. So I would recommend more of an unofficial change before entering into and filing a permanent order to change custody or decision-making or parenting time. Because once that happens, you have to wait for a change of circumstances and a time period in order to get a modification if it doesn't work.
I'm going to mediation for education, for sole decision-making on education, and my son's dad is fighting me that he doesn't want our child to go to the school where I work at. It's the #1 elementary school in Arizona. How can I request I have final say in education?
That's such a great question. And this comes up so often. And this idea of, this school is better than this school comes up a lot. These rankings I have seen are not very persuasive in my experience. I don't know if you have seen that as well.
The question was, how do I request it? You ask for it. And then you put down all the reasons why that's best for your child. And I'd also be exploring what are your co-parents' objections, and then looking to make arguments to rebut those objections as well. But in most cases, most people are like, oh, great, mom's at the same school the kid's at, fantastic. So I would really be questioning, why doesn't he want the kid to go to the school where you're a teacher at? And then try to rebut those arguments and show the judge, oh, he's just being selfish or controlling, or, you know, that he's not acting in the child's best interest. Let's see here. If a parent hasn't been involved for the first 2+ years of a child's life, is it more likely that a judge will grant no parenting time, or are they still likely to give some sort of parenting time?
They're likely to get parenting time.
Sometimes it'll happen through what's called a graduated schedule. You know, they don't like go right to 50-50, but there's some time for them to start to connect with the child, and the parenting time grows over a certain amount of time.
I want to get to this last question, just one more, and because I think it's a really good one. She says, I'm afraid of potential problems that I will face if my husband and I have joint legal decision making, when I have made 99% of these decisions all along. Will I now have to start getting signatures from him on everything I do, and everything that was formerly decided upon? Do both parents just operate independently on what they think is best for their parenting time? She's wondering, practically speaking, how's this going to work?
I think that you need to really think about, what kind of level of communication do I want to have, and decide how you want to navigate this relationship. Because I think if you're going to demand information from the other side, but you aren't sharing that in exchange, then you've got an imbalance that may not resolve the issue. And sometimes it can be better to just have, you know, you share the information, whether or not the other side does, to show that this is where, you know, this is what you think is the proper level of communication. But, you know, you're in a situation where you can't necessarily control the other side. So I think a lot of this is deciding how you want to show up as a co-parent and being the leader in the situation. But, you know, this isn't necessarily stuff that a court's going to get directly involved in, other than maybe setting up a parenting app to communicate through, or some basic boundaries. But a lot of this stuff is just the parents figuring it out.
Right. Most of the time, there isn't a huge change. Parents are able to transition. There aren't major decisions that need to be changed. But I completely understand this, you know, the trepidation that comes. So thank you all for joining us for this webinar. I hope it's been effective and productive and useful to you. If you have other topics you want us to cover, please tell us. And don't forget to join us in the membership. It's a great value. And that coupon code again is WWLS30. Thank you so much, Julie.
Yeah, just one final comment I want to share from a member. She says, Win Without Law School is invaluable, whether you have an attorney or not. The greatest benefit of this program is changing your mindset from a defeated, fearful parent to an empowered, educated one. I have access to live Q&As 3 to 4 times a week. It's absolutely invaluable. Thank you.
Thank you.
Yeah, thank you for that input. So thank you guys for joining us today. Good luck with your parenting journey.
Bye.